But we're going to do, what we're doing today is reviewing not just inspections in depth or testing in depth, but we're basically talking about how they are separate and how they are different. We get a lot of calls about, can we do this? And it's usually, no, you can't, because that's a test and you don't have testing in your offer. Or we're going to talk about how you correctly put in testing in your offer. And then we're going to finish it up with going over the real estate condition report and how that jives with the seller's disclosure before any testing is, or before any inspections or testing are done. So that's basically the discussion today. And it's really important, I think, especially if you're new into the business or newer into the business, because it's probably one of the more complicated issues in the offer to purchase. So we're going to go over it, and we'll probably go over it again in 6 months and keep reminding you. Please, if you have any questions, just raise your hand in the chat or whatever, and we'll open it up to you. Otherwise, you can mute yourself and we'll get started. So the title of this is inspection / testing / wrecker, real estate condition report. And it's talking about disclosures and negotiations. So you and the seller, if you're the listing agent, need to have a real, is it improper to say come to Jesus meeting? But that's what you need. And make sure that the seller is upfront with you and is disclosing everything. And you might even need to throw in a kind of a scare to the seller on why disclosing everything is so important. And that's what a lot of this is all about. The inspection or testing should uncover things that the seller may not know about. And that's perfectly normal. A lot of us are living in our house for quite a while. You take things for granted. You might have to extra pump the one well or certain things like that, and you just take it, well, that's how this works. So when the inspection is done, the inspector will actually see things that either need replacement or repair, or could even possibly be a defect that you've grown used to, but the new buyer doesn't want it or doesn't want to deal with it. So we're going to start with inspections. Where am I going here? I lost my share.
Oh, here, let me. Um, I'll pull it up.
Okay. It just vanished.
That was very strange. Okay, can you see my screen?
When I get out of this thing. Yes, I can.
Okay.
That was weird. I was just advancing the slide.
Right. Okay, so here we go.
Yeah. All right. Trying to get it there. So in the actual offer to purchase, we're going to talk about inspections. And it's on lines 178 to 192 in the residential offer to purchase. Obviously, the lines are going to be different in the condo and things like that. But the wording is the same in condo and multifamily about inspections. And I've highlighted in yellow. I mean, obviously I went to highlight the whole thing, but highlighting in yellow are really the key lines that you're supposed to notice. Inspection is defined as an observation or property of the property. Can it be made bigger, Steph?
I have the full screen. Is everybody else seeing the full screen? Like, I
Yes.
don't think I can make it big.
Okay.
Okay. Felix. I definitely would not have an opportunity to make it bigger. So I wonder
I
what's
did.
going on.
Just did on mine, so that's good.
Okay, good. Okay.
So this is what's important. An inspection is defined as an observation of the property, which does not include an appraisal. It does not include testing or any other testing for leaking carbon monoxide or testing for LB gas or natural gas used as a fuel source, which are hereby authorized. Now it defines what a testing is. So inspection is observation. A test is defined by taking samples of materials such as soils, water, air, or building materials from the property for laboratory or other analysis. Seller agrees to allow buyers, inspectors, testers, and appraisers reasonable access to the property. That's if it's in the offer. Buyer or licensees or both may be present at all inspections and testing. And that's clear. Sometimes the seller doesn't want the buyer there or odd things like that. Sometimes the seller doesn't want to be there, or sometimes the buyer doesn't want the seller there. But this says who can be there, except as otherwise provided. Seller's authorization for inspections does not authorize the buyer to conduct testing. So if you just have inspections in your offer, you can't do a water test or you can't do a asbestos test or things like that. Any contingency authorizing testing should specify the areas of the property to be tested. And this is something I'll repeat when we see the testing contingency. This is one of my real gripes where they used to say on the line of tests, anything that the inspector recommends, or they leave it blank and don't identify any tests. And the agent usually comes back and says, but we don't know what tests we want. At that point, you just go over the different tests, and there are only a few tests really, but go over them and see if they are material to your buyer. Does your buyer have allergies? You might want to test for mold. You know, does your buyer have um, uh, respiratory problems and things like that? Then you do want to test for maybe for radon or air surfaces. So it makes it relative, but you have to actually name the test. Any contingency authorizing testing should, again, specify the areas of the property to be tested. For the purpose of the test, to determine if environmental contamination is present, any limitations on the buyer's testing, and any other material terms of the contingency. The buyer agrees to promptly restore the property to its original condition after buyer's inspections. Buyer agrees to promptly, this is important, promptly provide copies of all inspection and testing reports to seller. Sometimes pushback from an agent will say, no, we didn't send over the inspection report because we're not going to ask for anything, or there was really no defects, or it's not important to the buyer. It still has to be promptly provided to the seller. And that's hard printed right here in the offer, and it's not for argument. Seller acknowledges that certain inspections or tests might detect environmental pollution, which may be required to be reported to the Wisconsin Department. So that is the difference between inspection and testing. One of the gray areas in there is drain tile tests. If they're checking, if there's checking sort of water getting into the lower level of a house, the basement, sometimes the inspector will say, well, you probably should have a drain tile test. And so then the buyer wants a drain tile test. And because it's called a drain tile test, there's a debate on if you don't have drain tile test under testing, whether you can do a drain tile test. Well, the bottom line is a drain tile test does not fit the description of a test, defined as taking the samples of materials such as soils, water, air, or building materials from the property for laboratory or other analysis. So even though it's called a drain tile test, it doesn't meet the definition of a test, and it probably could be put under observation. But it is a little bit invasive observation, and it has to be returned to the state it was prior. Do you agree with that, Steph?
I do. I still feel like it might not be a bad idea to put it in like line 2 of the second bullet point under further
Mhm.
inspection of roof,
Yes, right.
chimney, drain tile,
Yes.
just to get ahead of it.
Yeah, I think that's on the next slide.
Yep.
Right. So this is what she's talking about, what Steph is talking about. This is the actual inspection contingency section. And it's contingent on a Wisconsin registered or Wisconsin licensed home inspector performing a home inspection of the property after the date on line such and such. This sort of talks about pre-inspections that a seller might get. It's not done, usually done before it's listed or whatever, but it's not done after the date on line 1. So they may use it for information, but the buyer still, in order to fulfill the inspection contingency requirements, should get the inspection after the date on the offer. And then this is what Steph was regarding. This offer is further contingent upon qualified independent inspector or independent qualified third party performing an inspection of, and as in this line, additional property components or areas you know that the buyer would like inspected right away. This is where you could put like drain tile inspection, or you can put chimney if the chimney looks a little funky up there. You might want to put that in there so you can get an additional property inspection of that area. Swimming pool, the foundation. They even give you these examples. But put those in so you are free and clear to go have those separate things inspected after, maybe even with a different inspector, while you're still in the inspection contingency time frame. And number 3, buyer may have follow-up inspections recommended in a written report resulting from an authorized inspection, which means if the inspector who goes through first recommends, say, a furnace inspection, or recommends a, there are just tons of extra things that could be done. Then this gives them the right to do it if you're putting those lines on, if they're specified in those lines. Buyer shall order the inspection and be responsible for all costs of the inspection. As the buyer's agent, do not order the inspection. You may give your buyer maybe 3 different inspectors that they can try with their contact numbers, but you do not make the phone call to schedule the inspector, or don't pay for it unless you have a little agreement. And another thing, buyer's agent and the buyer should provide sufficient time for the home inspection, because there can be follow-up inspections or more negotiations. You need to maybe get some bids from contractors and things like that. Another thing I'd like, if you want further inspections, it's a good idea to get a person who's qualified in that area and not necessarily a contractor for that area. A contractor would maybe looking at it as potential business and give a bid that reflects that. If you have, say, somebody like an engineer or somebody who is not a contractor but knows a lot, is an expert in that business, that might be a better follow-up inspection rather than having a actual contractor do it. Any questions about this part? Nope. Okay. So then you put in the time frame. There's example here within 10 to 14 days. I think 14 is good. Or 15 if left blank. Delivers to the seller a copy of the written inspection report dated after the date on line 1 of this offer and a written notice listing the defects identified in those reports. So you have to use the inspection report to go to the defects page and list it. There is where you're talking about the notice of defect, and those defects have to be on that summary of the inspector. So if there is going to be a notice of defect, that's where you have to pick it from. And then it gives you a definition of a defect, which is, yeah, remember a proposed amendment is not a notice of defect. And we've had a whole contract training just on the difference between amendments and notice of defect. To make sure you understand that distinction. Defects do not include structural, mechanical, or other conditions, the nature and extent of which buyer had actual knowledge of or written notice before signing this offer. That's the tricky line in there, and make sure that your buyer understands that. If you get to a point where you're writing notice of defect and the inspector may have listed it in his report as a defect, but it was something, say, that was on the real estate condition report on the record, or it was something in the details in the data information from the seller to anyone interested. If it's something in any other disclosure that the seller makes, that means that if you were aware of it before you wrote the offer, then you cannot use it as a defect in your notice of defects. If you want to get around that, the best idea for your buyer's agent is to cross out lines 210 and 211, which means any of those defects known to you, known to the buyer prior to writing the offer, can be in the list of defects, in the notice of defects. A defect is defined, and this is very gray, on lines 445 and 447 in the offer, means a condition that would have a significant adverse effect on the value of the property. That's one. Two, that it would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced, would significantly shorten or adversely affect. So those are the three conditions that define a defect. As I say, they're kind of gray, and that's what our courts are for, or that's how the lawyers put that in the offer. So
Right.
arguments about, oh, that's not a defect, that really has to be established by a court, whether it's a defect or not. The court will usually always lean toward the buyer's opinion of a defect, unless it's really stupid. Like one defect list that the buyer put on their list of defects was crabgrass in the yard. And that didn't pass the smell test. Okay, next. So the next part of the inspection contingency, and it's in the testing contingency, and it's in everything in your offer. If there is right to cure, which do you choose? Do you give the seller the right to cure, or do you give the buyer the right? You don't give the seller the right to And what it defines is really who has control over the offer. If you give the seller the right to cure, which means he can fix any defect listed or all of the defects listed in the notice, then the transaction can go toward closing. If you do not give the seller the right to cure, that means that as soon as the buyer sends the notice of defects, listing the defects, the offer is terminated right then and there. So not giving the seller right to cure, the ball is in the buyer's court. Giving the seller right to cure obviously puts the ball in the seller's court. But it is something that in these recent markets, I would say maybe last 10 years, where it's been a seller's market, it's almost been universally written in the offer that the seller has right to cure. It's an incentive to the seller. So at least the seller has more control over the offer. So in filling out the right to cure, you strike either shall or shall not. It defaults to shall if neither is stricken, has the right to cure the defects. If seller has the right to cure, seller may satisfy this contingency by, and it gives the time frame. You know, it's generally 10 days. Sometimes it can be shorter, which is what the seller likes. Sometimes it can be longer, which is what the buyer likes. But after buyer's delivery of the notice of defect, stating the seller's election to cure defects. Curing the defects in a good and workmanlike manner. That's great. And we have a clause that you can pop into your offer that clears that up. That the seller has to do it, provide liens and receipts, and has to be cured prior to a certain date and all things like that. But if you don't have that clause popped in there, and we'll show you later, it's just the seller has to perform in a good and workmanlike manner. Delivering to the buyer a written report detailing the work done no later than 3 days prior to closing. This offer shall be null and void if buyer makes timely delivery of the notice of defects with inspection reports and the seller does not have the right to cure. That's done. The offer is over. But if the seller has the right to cure and he delivers a notice back saying he's not going to cure, the offer is done. Or if the seller does not timely, he says you would give 10 days to decide whether he's going to cure or not. And if he doesn't do it in that time, that's an automatic, the offer is dead. So those items in there determine what happens with the seller having the right to cure. The seller does not have the right to cure. All it has to be is the buyer sends the notice of defects and boom, it's dead. Any questions on right to cure, call me, call Steph. You know, for independent questions on your contracts, maybe there's a story behind it, we'll be happy to answer. But it is definitely one of the more complicated parts of the contract. And here's the concept of only triggered if there's a notice of defect. Sometimes I get questions from agents, they've just got the report and they haven't decided whether they're going to file a notice of defects or not, or send an amendment to negotiate with the seller a little more. And in the amendment, they're talking about right to cure. And I'm going, wait. There's no right to cure when you're talking about amendment to negotiate. It's only when you send a notice, and that's a notice to the offer to purchase, and then you put on the first line, this is a notice of defects, to which a list of the defects to which the buyer objects. It may never be triggered in an offer. Determines who has the power to declare the offer null and void. As I said, seller either has the right to cure or does not. It is indicated in the offer and defaults to the seller having a more advantageous for the seller to have, more advantageous for the buyer if the seller does not have. So on this whole part of the inspection contingency and right to cure, are there any questions? Or do you have it down pat? If you don't have, go ahead.
Oh, I was just going to comment, this is definitely one of our harder concepts. Joan and I always say this, and multiple representation are the hardest concepts in our contracts. And a lot of times it's hard to get a grasp on it until you like see it played out.
Yep.
So I know that was the case for me. So if you don't quite get it, don't worry. It's a hard one.
Yeah, back in the day, I wrote an offer where the seller did not have the right to cure. And I sent it over and the listing agent called me back and he was mad at me saying, why would you do this? And back then we really didn't, it was sort of new in our contracts and we really didn't have a grasp of it. And
Mhm.
I said, well, you know, if the buyer doesn't like the defects, the buyer can get out of the contract. And he replied to me, then this is nothing but an option to purchase. And I
Mm.
always took that thing, right, it's the seller really doesn't have much security in this
Right,
offer if the buyer can get out on just one little defect.
right.
So I think the next slide is now we're talking about testing. No,
Oh.
amendment in practice. Okay, so this is quick. Always do an amendment first. After the reports are given to the seller right away, and you and your buyer are going over the reports, and the buyer is deciding if these defects are something he can live with, he can fix, or he will not buy the house with these defects, and he wants the seller to cure them. And I keep using that word cure. Cure means fix. It doesn't mean dress it up. It means it may need replacement. It may need taking out and replacing. It may need just repair, but it means cure, put it the way it should be working. And this, using the amendment first, this is where you and the seller, the buyer and the seller negotiate. Maybe we'll lower the price a little bit. Maybe we'll give a um, incentive to the buyer as far as closing cost credits. Maybe we'll modify it and have something replaced instead of have something repaired instead of replaced. So these, and then putting in the follow-up inspections. Get a chimney guy out there to do the chimney. Don't just rely on the inspector's binoculars. Clarifying language around the right to cure and good and workmanlike manner. So I mentioned this, see the clause library to pop this in your offer. It's titled right to cure, and copy and paste that, pops into your offer, and it says in jest that well, instead of good and workmanlike manner, it's getting a licensed contractor in the state of Wisconsin, getting invoices, getting lien waivers, all the things that nail down that phrase, good and workmanlike manner. So it's very important and very smart of you, but the idea is you have to put it in your offer at the onset. You can't try to shove it in the offer with an amendment. That has to be in there from the beginning. And then market of the moment language, we've got that addendum AC, gives an inspection cap. It's another way, another deeper way for the buyer and the seller to negotiate defects.
And
So
here's that.
here's the clause. Yeah, seller shall have the right to cure in a good and workmanlike manner using professional licensed experts with the benefit of permit as required and in accordance with the municipal building code. We actually should take that out. And generally accepted construction and safety standards. Scope of work shall be defined by an independent third-party expert. So that's a little bit more defined than good and workmanlike manner. So pop that in using the clause, it'll pop right into your additional provisions. Your most important value to your client is to negotiate for your client's needs. I'm saying negotiation is your number one skill for why you should be hired, especially in the inspection contingency. Use the amendment for this and make sure you have given enough time to arrive at a win-win. It's a good paragraph from Steph. Nice.
Can I just clarify really quick before we move on?
Please.
Yes.
Okay, so you said so they have the right to a cure. Do I need to send the notice of defects and an amendment, or can I just go to an amendment and say, we need these three things fixed by such and such and date?
Right. That's an excellent question because that's where a lot of the confusion is. Is understanding the difference what an amendment is. The word amend means to change, and what a notice of defect is. And that's a notice saying, we're not looking for an agreement here. We're giving you notice of actual defects. So that's the trip line. That's the red line in the sand or whatever, is the notice of defect. Prior to sending a notice of defect, that's when you pull out the amendment. You use the amendment first if there are things that the buyer wants fixed. And you can talk about, the buyer maybe want closing cost credit or lower the purchase price of the house, or the seller to fix, the chimney prior to closing or 3 days prior to closing. All those terms and negotiations. And in that amendment is where you can use also to be done by a licensed contractor with permits and invoices and lien waivers. So the amendment, you can talk about what needs to be done, how it has to be done. You can even ask who's to do it. You can ask all kinds of things to the seller, telling them how they want it fixed. So there's a lot of talking, a lot of negotiating back and forth with amendments. If you reach a standstill and the seller won't sign any of the amendments on how to do it, that's when you say, okay, we've reached the line in the sand. Here's the notice of defect. You either fix them or this deal is done. You have the right to cure, but you have to fix all the defects that are in my notice of defects, or else this offer is dead. So that's the difference. They are to be separate. Amend means to talk, change. Notice is a statement. It's like, here it is, take it or leave it. Is that clear?
Yeah, I think. And then the notice of defects, that's a single form, and then you include the defects on that? Is that
Yes.
okay?
Yeah.
Okay.
You take it's a blank form called notice to the offer to purchase. And so you fill that out by stating on the first line, this is a notice of defects. So you change this notice form into a notice of defects. And then your next line is, these are the defects to which the buyer objects, on the property at such and such.
Okay.
And then you list them as they are to be cured. You can't tell them in the notice how it's to be done. You can't tell it who has to do it or what they have to provide. You can't go any of that language like you can an amendment. On the notice of defect, you say chimney flashing needs replacement, or chimney flashing needs replacement, or whatever. But you just list the defect. You don't list who's to do it, how to be done, or anything like that. And it's just a list.
If I give the amendment, then I'm done. And they agree to the terms on the amendment, then I don't need to include the notice of defect.
Perfect.
Right.
Okay,
Exactly.
got it. Yeah. Okay, thank you.
Okay.
And another way to think about this too, Julie, is that we hope you never get to the stage of serving a notice of defects. Like the goal here is never to even get to that point. Like we're hoping that you, buyer and seller, come to a meeting of the minds via that amendment process. and can agree on how things are done, when they're to be done by, et cetera, and a notice is never even going to come into play because you guys have gotten it all figured it out via that amendment. So,
Yeah. But it's important, I'm glad you asked that because it's important how you fill out a notice of defect too. You can ask for all the provisions in the amendment. You can ask for no provisions in the notice. That's why you want that clause in there at the start of your offer, because you can't negotiate for that later on.
right.
But thanks. Any other questions about the inspection contingency and notice and right to cure? Okay, so we'll go on to testing. Now the testing in the offer to purchase, there is one test, and that's the radon test. It's in the offer to purchase, right near the
I think
inspection.
it's right after. Yeah, I think
Right
it's right
after.
after. Yep.
Right. All the whole testing contingency, however, is in lines 16 through 30 in the, be careful to note this, GMAR addendum A. So when you're searching for addendum A, make sure it says up in the upper right-hand corner, GMAR addendum A. There is a Wisconsin addendum A, and it deals mostly with property conditions that you would find out in the rural areas and things like that. This addendum A is more pertinent to our residential areas in the state of Wisconsin. So it's lines 16 through 30 to be attached to your offer. Do not write on the lines where it says there's a blank line of the tests to be given. This is too small, you can't see it, but it's.
I'm gonna see this on the next page. Hang on. Oh,
I
I can
thought-
pull up. I can pull up a different version.
Oh, you're so good.
I have way too many windows open. Are you guys all seeing the zip forms? Joan, are you seeing the zip forms?
Yes.
Okay.
Oh, yeah.
Um,
You can see that it's titled, it starts out with Greater Milwaukee Association of Realtors. So that's how you know you're getting to the GMAR addendum A.
okay.
Oh, much better.
Here we go.
So the contesting contingency reads, this offer is contingent upon buyer obtaining a current written report from a qualified asbestos, excuse me, qualified independent third party documenting the results of the following tests. Remember back in the offer to purchase, it said, when you get to testing, you have to identify specific tests conducted pursuant to the applicable government or industry protocols and standards. So asbestos testing for that would definitely be one. And that's pretty common, especially in flooring and ceiling in houses back in the 40s, 50s. Air quality tests, mold is a big one. I ordered some carpeting for our upstairs, which is like a half story, dormer upstairs. And it had a vinyl over the whole floor up there. And I think it was Home Depot would not let me have the carpet installed until I did an asbestos test on that flooring. And thank goodness it came back negative. And I didn't have asbestos in that flooring, but there's a lot of flooring in tiles that were used or vinyl sheets that were used in the 30s, 40s, and 50s. So that's where you put the test you want done. Which may affect the health of the occupants or the value or structure of the property. Within how many days? 15 if left blank. You can have it be the same number of days in the inspection contingency. At buyer or seller's expense, excuse me. And it's usually done by the buyer's expense. That's default. Testing shall be performed by a qualified independent third party. Seller shall not have the right to cure. So that line is important in there. If they find that there is asbestos in the flooring, in the kitchen, say, does seller have the right to cure or does he not? Generally on these tests, you usually always give the seller the right to cure. Sometimes the cure on these things, like water tests, which is the next contingency, it usually always give the seller right to cure on these. They're very simple cures and not very expensive. So that's really what it is just making sure that it is in your offer. If there are any things in the offer that you can tell from the showing of the property or looking through details about the property, you say, oh, this was built in 1945. There probably is going to be asbestos in the kitchen tiles. Be prepared in your offer for doing that. As I said, do not write in that blank line any test recommended by the inspector. We don't want to marry the inspection and the testing together. They should be kept totally separate. List the tests that are relevant and important to the buyer. So say the inspector is going through the house and he sees some mold back in a closet or something like that. It's too late at that point because you already have an accepted offer to put in, I want to test for mold. I mean, you can try an amendment in doing it, but you know, the seller says, well, I'm not going to let you do that. You've got to figure that out on your own. So to have these things up front, if mold is a concern, if the house is older, there are certain tests you might want done. So lead-based paint is separate on Addendum S, and you can ask for lead-based paint to be inspected in Addendum F, see if there's lead in the wall painting or railings of stairways or things. But this is putting in your offer from the beginning in Addendum A under testing contingency, the test that you might want. Now, if it gets to a point that the test was not relevant, or you decide not to test actually after the offer is accepted, if you have a lender, you might want to let the lender know that you waive the testing contingency, because he'll be looking for the report of what tests were done. Anything else, Steph, can you think of under testing?
Not really.
Yeah, it's not very complicated, but
No.
the key line is to keep testing separate from inspections. They're not to be lumped together, and they say that very clearly in the offer to purchase.
Mm-hmm. Say it about 5 times.
Yeah. Now, bringing this all together, this real estate condition report, and we've talked about it. We've even had whole contract trainings just on the real estate condition report. So you could go back into the library if you want a more thorough instruction on it. But for purposes of today, I just want to show how it relates to the seller's disclosure on what he knows about his house and what he doesn't know about his house. Who is going to fill out the property condition report? If he is a seller, either in an estate, he's been designated as the seller, or he lives there and he is the seller. As long as he's not court appointed, he is not exempt from filling this out. Some people will say, oh, he hasn't lived there since he was, you know, in his 20s. That doesn't matter. He's still, if he is the owner of the house now, he is the seller. And even if he hasn't lived there in a long time, he still has to fill this out. The list of exemptions are clearly written in the top, at the top of the real estate condition report, but the agent cannot assist in helping them fill that out in any way. You step back, you can tell them if they need an attorney's advice, they can ask an attorney, but you are not to provide assistance at all in their filling it out, whether something is a defect or not, or whether how they should fill out a certain line. You do have to stay mum from that. Next page. You have to have a little talk with the seller about the importance of disclosing everything. Some sellers will, you know, they did just deny it. It's not that big of a deal. It's not a defect. It's not, you know, we've lived with it for 20 years. We've never had any problem with it. That kind of attitude, you have to give them a little lecture on how dangerous that is. Because the #1 lawsuit in home transactions is on non-disclosure. And all it takes is for a buyer to move into the house thinking everything's fine, didn't learn a thing from the inspections or anything. But as soon as he's in the house, something goes wrong. You know, the basement leaks, or there's chimney leaks, or there's squirrels in the attic, or things like that. And the buyer is obviously very upset because these things are happening, and there was nothing on the condition report. There was nothing in the inspection that saw any of this. And now the buyer owns this house and has to deal with it. The first thing he does is he calls a lawyer. Because if he calls you, the agent, you have to say, I'm sorry, I can't help you. The deal has closed. It's past closing. I no longer have a role in your transaction since it is closed. You need the assistance of an attorney, and I'm not an attorney. So you have to beg off, and a lot of times that's difficult because you've been helping them all along. But now that it's closed, the buyer has moved into the house, the buyer sees these defects, and his alternative is to live with it or to call an attorney. And he will sue the former owner for non-disclosure. So those are the stories you have to tell the seller. It's very common. It is, you know, if they find something, and all they need moving in the house and something like that shows up, and they're talking to their new neighbors, and he said, oh yeah, you know, he had basement work trucks over there all the time. Or, you know, he had roofers up there all the time, kind of thing. And they'll find out that he was very aware that this was a problem in the house, but he didn't put it on his real estate condition report. And that's all the evidence a new buyer may need to say that the seller knew about it, but did not disclose it. So after the seller has filled this out on his own, have that available for buyers agents prior to their writing the offer. They want to be able to read this record first. It's far better to disclose and deal with any defects during offer negotiations than during the inspection contingency period. So you can add certain things. You can justify the seller's price is because, you know, this is wrong with the house, but I'm telling you about it now. I'm not going to fix it, but that's the justification for the price I have. Things like that are easier to negotiate than finding it out in the inspection, or worse, finding it out after the buyer has moved in. See the definition of exempt buyers at the top of this form. If a quote seller is exempt, there is a form called the refusal to fill out the REC our form in zip form. And it just lists all the different reasons why he's not filling it out. And if he's a court-appointed seller, then he's most likely exempt unless he lived there at any time. And that's a little tricky one. Go to the next slide, please. So here is that top of the real estate condition report. And it describes, this is disclosure of the condition. This is a state law. This is not a real estate law. It is a state statute. It is not a warranty of any kind by the owner or any agents representing any party in this transaction. It is not a substitute for inspections or warranties that the parties may wish to obtain. A buyer who does not receive a fully completed copy of this report, and I'm going to stop and ask you to focus on the word fully completed. We had a lawsuit in Keller Williams a couple of years ago just because our agents left out, or seller, but the agent's responsibility was to make sure it was completed, and the seller left out a couple of the questions, and so he couldn't prevail. So a buyer who does not receive a fully completed copy of this offer within 10 days after the acceptance of the contract of sale or an option contract for the above described property has the right to rescind the contract. So if you wrote the offer, it's accepted, and yet still hasn't received the real estate condition report, that buyer can say, hey, I've waited 12 days, I still don't have it, I'm going to rescind my offer. Oh, excuse me, before 10 days. So that's why it's important to get this condition report to the buyer's agent prior to them writing an offer. Real estate licensees may not provide advice or opinions concerning whether or not an item is a defect. That's clear. And that's probably one of the most common questions your seller will ask you. You know, should I put this down? Is this a defect? You just say, you fill it out according to what you think. Or you can ask a lawyer. Concerning the legal rights or obligations of parties to a transaction. The parties may wish to obtain professional advice or inspections of the property to include appropriate provisions in a contract between them with respect to any advice, inspections, defects, or warranties. So the seller should get the advice of one of those professionals if they have any questions. Otherwise, it's to their best of their knowledge on their property. And if they haven't lived there, they still are required, say they remodeled it, they bought it as an investment, remodeled it, and we're going to flip it, but they never lived in there. They are still the owner of the house. They are still the seller, and they still have to fill this out as best as they can.
Can I just have it? Yeah, I do.
Good.
So what about the seller refusal statement?
Mm-hmm. Well, it states at the top that they are refusing to fill this out. And I've used it maybe 2 times when I was selling. Both times the owner, well, one time the owner hadn't lived there in about 20 years. It was vacant it was a beautiful 2nd floor condominium apartment. But he hadn't lived there in about 50 years and had it rented at one point, but most of the time it just sat there, and it was this beautiful place overlooking Lake Park. But he didn't want to fill out the report because he hadn't been in there. He hadn't lived there. They had a caretaker at one point just to keep an eye on the pipes and stuff. But he didn't want to be liable for anything he might say because he didn't know it at all. So he just filled it out saying, I refuse to fill this out. I don't want to be held liable. The other one was a big house in River Hills. Again, here the seller bought the house to dress it up a little bit and put it back on the market. And he never lived in the house. but because he was the owner, he was the seller, he was not court appointed, he had to fill this out, and he didn't want to. And it was the same sort of reason. He'd never lived in the house, he had never experienced it other than adding some improvements to it, but he didn't want to fill it out either. And it was fine. We just put out seller refuses to fill out the real estate condition report. But on the refusal to fill out the seller condition report, there is a list of reasons why. Why aren't you doing it? And mostly because the seller is court appointed. But if a court appointed person ever lived there, even when they were a kid, they would have to fill it out.
Okay, thank you.
Mhm. Next page. So in all transactions, the broker, this is where you come in. You're required to inspect the property prior to listing it and ask the seller for a written statement of property condition report, the record. The seller completes the record according to Wisconsin statute, chapter 709, the directions and definitions in the record and the advice of legal counsel as needed. Wisconsin statute 709 requires a residential seller to complete the record, whether they are broker assisted or for sale by owner. So even FSBOs have to fill these out. Or risk rescission of the offer to purchase. So if they don't fill one out, the buyer with an accepted offer can pull his offer. Say if he gets one too late, he gets a record too late, or he never gets one, he can back out of his offer. Generally applies to all persons who transfer real estate containing 1 to 4 dwellings, including condominium units, timeshare, and living quarters. So it's not something we can treat casually. Next slide. And this talks about rescission, and it can be a little complicated, but it is something, if you are a listing agent for this house, you get the record filled out as soon as possible, have it available in MLS. Make sure that the buyer's agent doesn't have a copy, they get a copy, because any time that drags on to after they have an accepted offer that they don't have a copy of it, they can rescind it, which means they pull their offer, they get their earnest money back, and they have to do their rescission in writing and deliver to the seller or the seller's agent within 2 business days after the buyer or the buyer's agent receives the record. So they have 2 business days to decide to rescind if they get it, or within 2 days after the record was due. So it's an important if you're the seller, and it's very important if you're the buyer's agent, not to lose your buyer's rescission right. Any questions on rescission? Just remember how to spell it. RESCISSION. Next one. Okay, these are the exempt ones. And I would say on this part of the record, this is where Steph and I get most questions. Is he exempt? Or they don't ask the question, and it turns out that they should have done the record. Number 1, personal representatives, trustees appointed by conservators or other fiduciaries or subject to supervision by the court, but only if those persons have never lived in the property. This does not apply to powers of attorney. They wouldn't do it. Number 2, real estate that has not been inhabited, and that's generally new construction. Nobody's lived there. Nobody's moved in. You don't have to do a property condition report for new construction. Transfers exempt from the real estate transfer fee, like family, between spouses, foreclosures, probate transfers. They don't require or need a record. If a seller is claiming he or she is exempt from completing the record, the broker may review the WRA seller refusal statement regarding condition or disclosure report. That's the form I'm talking about. Available in zip form. So if you're searching for it, start by writing in WRA seller refusal and ask the seller to complete the form. The form includes the check boxes identifying potential exemptions, what I just said. So you attach that to the documents. You can make note of it on the real estate condition report with nothing filled in, and then you can attach a WRA seller refusal form with it. Is that clear to everybody? If the seller has never lived in the property but has received a pre-inspection report or any previous reports or evidence of work done, that information can be attached to the record or itemized by the condition on the condition report. Full disclosure of any information on a property protects the seller and the firm agent. So it's you and Keller Williams that also could be liable if full disclosure or incomplete form is provided. If a defect has been corrected or repaired, it is good business practice to record that information and the date of correction in the seller condition. So there is a paper trail from the seller. You know, maybe there's a leak in the kitchen ceiling in 2022. So it's not a defect now, but trust me, it really looks much better if you put in the record, leak in the kitchen in 2022, repaired and no evidence of leak since or something. So a paper trail is very good, and it makes it much better than to pick up a real estate condition report that says no, 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 all the way down. You know that's impossible. Next one. That's it.
All right.
That is it, yeah. So that's pulling them all together. It's giving some good idea as to what you are responsible for as a listing agent and as a buyer's agent. Steph and I are always available to clear any aspect of these up for you. But you want to make sure that you get the knowledge, have it, refer back to this, the recording of this, or you know, all of our contract trainings are in the library if you need any review on any topic.
Thank you.
Thank you, everybody.